What a lot, some of the hell. Oh, thank you. I think so. I just he's one of our biggest as one oh, Derek, that's your. On a paper publication, I don't know whether saying to the Chinese or if you petition on Kandala, I tell you, eight, not 9 documents. Like, that function order discussion. They're not.
Yes, please, my lord. My lord, I beg to mention admission item 3 to 14. I have received instructions only this morning.
Okay,
So with the consensus prayer, I may be granted 3 weeks time to file my affidavit.
yes, Mr. Lima.
Yes, Mr.
Mr. Lima, upon learned counsel part of petitioners is present. Mr. L.T. Sanctum, learned additional advocate general.
Yes.
Nagarani paying for the state respondents has submitted that he has received the necessary instructions. You want to file separate
For all the
affidavit or
yes, my
one
lord, separate.
separate instructions to file counter affidavits in this batch of petitions, and has thus submitted that the counter affidavit will be filed within 3 weeks' time.
Yes, ma'am.
So yes, thus paid for listing of the cases after 3 weeks. Okay, the prayer is allowed. Raise the cases. After 3 weeks, the state respondents will ensure that the counter are filed, counter affidavits are filed within 3 weeks' time.
Much.
May it please, my lord.
Yes.
Chip, item number 27, allow me to move one unlisted IA lordship. It is in connection with this case that is coming up today. Item 27. Lordship.
Your Lordship, I beg to mention hearing item number 33 and 24 on behalf of Viso Cray, Lordship. Kindly let the matter come up after the vacation. Consent from the petitioners has also been taken.
Okay, Miss Esther
Miss Lucino, ma'am.
Olusino, learned counsel for the petitioner is present. Miss
Menoshan for the Menoshan for the private respondent.
Okay, Miss so-and-so for the private respondents are present. Miss
AIME.
AIME, learned state counsel. Representing Miss P. Shukri, learned additional advocate general, Nangaran, has paid for listing of the cases after 2 weeks.
After the vacation, yes, Your Lordship.
Okay, after 2 weeks. On the ground that Ms. Shukri has difficulty to address the court today. As the prayer is not opposed by the learned counsel for the petitioner, the prayer is allowed, lays the case after 2 weeks on date to expired office.
Your Lordship, similar prayer for item number 22 also. After the vacation on behalf of Viso Cray. Consent has
Okay.
been taken, Your Lordship.
Miss
Personalized LKR for the petitioner, Lordship.
petitioner present. Okay, same. IME on behalf of Shukri,
Much obliged, Your Lordship.
2 weeks.
Yeah, Mr. Lordship. Lordship, I beg to mention item number 20, Lordship.
20.
20, Lordship. Here I'm yet to receive instructions, so can you permit me some time, Lordship?
S. Chang.
Yes, Lordship.
Okay. Anybody for the petitioner, Miss?
You mentioned question.
So in short, learned counsel for the petitioners, Miss S. Chang, learned government advocate for the state respondent has paid for and is granted. How much time you need?
3 weeks, Lordship.
Okay. To obtain necessary instructions and to file the counter affidavit on behalf of the state respondents. List the case after 3 weeks.
Lordship, I have similar prayer for item 21, Lordship. 21.
21.
Yes, Lordship.
Petitioner same?
Yes, Lordship.
Same.
Obliged.
Lordship, I beg to mention item number 18, Lordship.
Hmm.
18, on behalf of M. Longkumar, Lordship. I'm here to receive instructions, so can you grant me 3 weeks' time, Lordship?
Wrong.
18.
18.
No, no. 18, 19, I'm lost. 17, 18, I'm lost. Yeah. 18, you mentioned 18.
Yeah.
No, Your Lordship, 18 is a fixed matter. We have fixed it. It is not the council representing the state is me. I think
Okay.
she has been misinformed. It's 17, 18, I'm lost.
Oh, Lordship. Oh, please, Lordship. Lordship, item 23, Lordship.
23.
23 on behalf of V. Jumomi, Lordship.
Yes, Miss
Here also submitted prayer, Lordship.
For the petitioner.
Petitioner, President Chang, on behalf of
V. Jumomi, Lordship.
PG Momi. Okay, how much time?
3 weeks, Lordship.
Okay, 3 weeks.
Your Lordship, instead of 3 weeks, I pray that the matter may be listed after 2 weeks, since it's a matter of urgency.
No, 23, 23. I think 23. Yes, 2 weeks.
Yes, Your Lordship.
Earlier, 2 occasions you have prayed for time.
Lordship.
Since July. Okay, 3 weeks.
Obliged, Lordship.
1 week is holiday.
Instructions.
3 weeks.
Obliged, Your Lordship.
Lordship, I have submitted prayer for item 25, Lordship. On behalf of M. Longkumar.
These are orders. Let us see.
Okay, Lordship.
Yes, my lord, I for the petitioner.
Let us see whether maybe for another region this may have come, apart from filing of affidavit. We'll look into it.
May I please, Lordship? Lordship, I beg to mention item number 15, Your Lordship.
15.
Yes, Lordship. Lordship, here the leading counsel, Peace Ray, has some personal difficulty today, Your Lordship. So if this matter can come up after 3 weeks, Lordship. I have
P. Suryan,
Yes, Lordship.
you are made of hero.
Lordship.
Yeah, Mr. M. Bhero, learned counsel. But a petitioner has submitted that he is, in this case, he is being led by Mr. Suryan, P. Suryan, who has some difficulty. There was some inconvenience to make submissions today. He has just prayed for listing of the case after 3 weeks.
Lordship.
Okay.
Much obliged,
The
Lordship.
prayer is allowed as the prayer is made with the consent of the learned counsel for the respondents.
Much obliged, Lordship.
Full stop. Mr. K. Angami, Learned State Council. And Mr.
Sir,
Your name, please.
Pangom W. Kaman, on behalf
Order.
of
Private
respondent number
respondent.
6.
Respondent number 6 are present.
Right.
May I please, Lordship? Lordship, I beg to mention item 19 on behalf of M. Longkumar, Lordship. I have similar prayer. I'm yet to receive instructions, so can you grant me 3 weeks' time, Lordship?
Okay. Mr.
No claim,
Learned Counsel for the petition is present, Ms. H. Chang, Learned Government Advocate, representing on behalf of Mr. N. Longkumar.
M. Longkumar,
Learned
Lordship.
State Council has submitted that the instructions are yet to be received to file a counter affidavit. Post of she has thus paid for 3 weeks' time to obtain the necessary instructions and to file the counter affidavit on behalf of the state respondents. The prayer is allowed to list the case after 3 weeks.
Much obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention hearing item number 32 on behalf of my senior Santiago, Lordship.
Yes.
Let the matter be listed after 3 weeks, Lordship.
Okay, on the prayer of Mr. So-and-so, Learned Counsel for the petitioner, list the case after 3 weeks. It is submitted to Mr. Angami, General Public Prosecutor for the state, is present and has no objection to the prayer for adjournment.
Take your place.
Worship, I beg to mention item 29.
29.
Yes, that's come up after revocation.
Okay.
In similar in some petitioner, I'll be filing a writ appeal. They have preferred to appeal.
Okay.
So
Mr. Imti Longchar, Learned Counsel for the petitioner is present. Mr. Yangarvati, Learned Central Government Council, has made a prayer for adjournment of a case.
after the revocation, Lordship.
Okay, for 2 weeks.
All right.
Okay, as the prayer is not objected to by the Learned Counsel for the petition, the prayer is allowed, is the case after 2 weeks.
Much obliged.
Please, Your Lordship, I beg to mention hearing item number 37. Your Lordship, this is a consensus prayer.
Oh,
If the
27.
matter may come up after 4 weeks.
27.
37, Your Lordship.
37. Okay, Ms. Smith,
And solo.
M. Solo. Learned Counsel for the petitioner, with the consent of the Learned Counsel for the respondents, has made a prayer for adjournment of the case for how much?
4 weeks, Your Lordship.
4 weeks. First of the prayer is allowed, list the case after 4 weeks.
Much.
Lordship, I beg to mention item number
16.
Lordship. Lordship,
Yes.
I'm representing response. Lordship, on receive of the instruction from the client, Lordship, there's some difficulties for me to represent respondent number 3 to 8, Lordship, because there's conflict of interest between the respondents, Lordship. If I may be allowed to withdraw representing respondent number 3 to 8, Lordship, and I'll represent only 1 and 2, Lordship.
Okay, make an application
Lordship.
in writing
Lordship.
to the registry
Lordship.
so that we can pass an order,
Lordship.
right?
Lordship.
So what is your prayer today?
Meantime, I may be allowed 4 weeks time to file affidavit in opposition.
Okay. Yes, your state. State is respond number?
9, 10, 11.
Okay, 9, 10, 11. Okay, Miss
And solo.
Anne Solo, Learned Counsel for the petitioners present. You have filed your affidavit. Okay, Miss Amy, Learned State Counsel, representing the respondent number 9, 10, and 11 has submitted that the state respondents have already filed their counter affidavit. First of Mr. Muajami, Learned Counsel, who had earlier entered appearance for the respondent number 1 to 8,
Lordship.
has submitted that he might withdraw the power to represent the respondent number 1 and 2.
3 to 8, Lordship.
3 to 8.
Lordship.
And he would take the necessary steps in the meantime. Those stuff. He has also prayed for listing of the case after 4 weeks for filing of affidavit on behalf of the respondent number 1 and 2.
Lordship.
Okay. The prayer for filing affidavit, prayer for time to file counter affidavit on behalf of the respondent number 1 and 2 is allowed. Full stop. Mr. Jamil is at liberty to take necessary steps for withdrawal of the power on behalf of the respondent number
3 to 8.
3 to 8 by intimating to the registry
Lordship.
in writing.
Lordship.
Please the case after 4
Much.
weeks. Any interim order?
Your Lordship, it's until further orders. Please, Your Lordship, I beg to mention hearing item number 35 on behalf of Aliralo.
35
Yes, Your Lordship. Yes,
on
the
behalf
affidavit-
of R. Iralu.
Yes, Your Lordship.
Okay, Miss
Manashino.
Learned Counsel for the petitioner has submitted that in this case, she is being led by Mr. R. Iralu, Learned Senior Counsel, who has personally inconvenience to appear today. Also, she has just paid for listing of the case after
2 weeks.
3 weeks. Okay. Mr. E. Thibapong,
Yes, madam.
Learned State Counsel for the respondents, state respondents is in attendance and has submitted that he has no objection to the prayer submit. Also, the prayer made on behalf of the petition is allowed, leaves the case after 3 weeks.
Lordship, interim may
Much
continue.
Interim, the interim of the past trial shall continue till the next date of this.
Much obliged.
For admission, item numbers 1 and 2.
May I please, Your Lordship? Lordship, I beg to mention on behalf of V. Jimomi, Lordship.
Hmm.
Here pleadings are complete, so if this matter can be listed after vacation, Lordship.
You are for PG movie,
Yes, Lordship.
already admitted for hearing.
Yes,
Yes,
Lordship.
my lord.
Yes,
So after vacation, Lordship.
Jimomi is not available.
Yes.
He has
Yes, in
difficulty.
court. Yes.
Okay. Miss Esther
Miss Lucino, ma'am.
Lucino, I'm sorry. Learned counsel for the petitioners. 1 and 2.
Yes, my lord, 1 and 2.
Okay. Is present, first of Miss Chang, learned counsel, appearing on behalf of Mr. B. Jimomi, learned government advocate, has paid for time. First of, as the cases have already been admitted for hearing. Also, as paid, as sought for and agreed to, very learned counsel for the parties, list the case
After vacation.
okay, after. But this is not vacation 1 week, after 2 weeks.
Yes, Lordship.
For admission, item number 17.
May I please, Lordship?
Hmm.
Lordship, the matter pertains to non-payment of the contractual bill, Lordship.
Non-payment of contractor's bill.
Yes, Lordship. No, Lordship, the petition
When
was
is the work order
2014, Lordship,
completed?
completed within the time frame as per the work order.
Then any litigation in between?
Lordship?
Any litigation in between?
No, Lordship.
No.
No.
When
No,
did you file? 2025?
Yes, we have been given representation, Lordship.
Representation, whether representation prolong the period of limitation.
Lordship.
Your right to recover might survive, but your right to sue or litigate may not survive.
No, Lordship, as per the affidavit filed by the state respondent, now they are saying that since it's a centrally sponsored scheme, so the ministry has already de-linked the scheme. So unless the state, the ministry is made a
Any
part,
question or limitation has been raised? No.
it's an admitted fact we have done the work, Lordship.
No, question is about entertaining the petition.
Lordship.
Why should you entertain? Money claim.
Lordship.
After 11 years, why should we entertain?
Lordship.
What is the stand?
Lordship.
What you were doing for last 10 years?
Lordship, we have been approaching the authority.
Normally,
Yes, Lordship.
for,
I do admit.
for contractual dues, a writ petition is ordinarily not maintainable.
Yes, Lordship.
Right?
Yes.
It should be a civil suit.
Yes, Lordship.
And it is a money claim.
Lordship.
In a sense, it is a money claim
Lordship.
for recovery.
Yes,
And normal period of limitation is 3 years.
Lordship.
We are looking at a
Lordship.
claim which is after a decade.
Lordship.
And any admission of liability, the law says,
Yes, Lordship.
has to be within 3 years.
Lordship.
This petition, whether by law, will prolong the period of limitation. Their affidavit. Their affidavit, what they are saying? What
They're
they are
not
saying?
denying the amount.
They are saying that the central government.
Yes. No, Lordship, going by their own document at page 11, annexure. Lordship, this was written way back in 2017 by the government of India. After
Page
11, annexure B.
of
the affidavit in opposition of the state.
Okay.
This is a letter dated 13 February 2017. DO letter number 1111-NE under bracket 16 to 2012 part 1 dated 13 February 2017. Now
What is their stand as your product?
that the government has delinked.
Scheme has to be implemented by the state government from their resource. When it was deleted?
In 2017, as per this letter, Lordship. By the time I've already completed the work. Now, as per the ministry's letter, Lordship, the funding has to be by the state. Lordship, page 12 will also be relevant, Annexure C, Lordship. This is again written on 2018.
Is Union of India a party?
No, Lordship. We were not aware, we were not even informed that this funding is from the government of, because the work order itself has been issued by the Department of Tourism, Lordship. Lordship, may kindly come to page 15, Annexure 1. The type copy is at page 16, Lordship. Work order has been issued by the Additional Director, Tourism. No mention has been made with regard to the funding by the ministry. So we were not aware of the funding made by the government of India. It was only after filing of the affidavit.
Is there any agreement signed?
Lordship, yes, contract agreement is normally signed between the department and the contractor, and that is in the records, Lordship. If the record can be called, the record will speak by itself, Lordship.
Where is the completion certificate?
Lordship, that's the interesting part, Lordship. They have never informed us that the scheme has been delinked. And whenever we went for getting the completion certificate, Lordship, they refused to give us. But the village council, where we have, under which jurisdiction we have done the work, Lordship.
That we cannot take cognizance of.
Lordship, yes.
We cannot take notice of that.
Yes. But
I have seen, that is why I have asked.
Yes.
Page 23.
Lordship.
You have given a certificate from village council.
Yes.
They are not the implementing agency or executing agency.
Since the department is refusing to give us the completion certificate, Lordship, something fishy is going on. We were not made aware. Had the department informed us, Lordship, we could have been aware of all these facts.
Well, you are after the project for last 11 years.
Yes, Lordship. I do agree.
That is also not acceptable that you don't know.
Lordship.
Whether they have accepted in the counter affidavit that the work had been duly completed.
Lordship, no such specific mention has been made.
Lordship, no. We have categorically make a mention in para 6 of our affidavit, page 3, my lord.
They refused to give us a certificate. But when the council certified that the work is completed.
Mr. Moju, problem is that
Lordship, yes.
the case contract ordinarily not
Yes,
accepted.
by the executing agency, yes.
But in case they admit that work had been duly executed,
Correct.
this much money is payable, then in rare cases,
Yes, Lord.
this kind of repetition is to be entered,
Yes.
can be entered in.
Yes.
That is always discretion. Now you are having many difficulties. One is after a decade, representation
Yes, Lord.
will not prolong the
Yes, Lord.
period of limitation.
Yes, Lord.
In a sense, it is a money claim.
Yes,
Though in writ petition, period of limitation is
Lordship.
not, but Constitution bench has said it is to be followed in case it is money claim.
Yes,
It is to be 3 years in a sense.
Lordship.
Secondly, thirdly, no admitted liability. Somebody, village council,
Lordship, here is an issue where they are not even admitting.
yes, you have spent the money.
Denying also.
That is why I am hearing you for 5-10 minutes. Otherwise, I would have dismissed it.
Lordship.
It appears that you have spent some money. That is why I am looking at some document.
Lordship.
But they are not admitting.
Yes.
Completion certificate issued by village council is not a valid document. They are saying.
Going by paragraph 6, they are not even admitting, they are not even denying.
Yes, how can we go on decide with the repetition? It is difficult.
I'll leave it to your Lordship, yes.
We know, but the period of limitation cannot be extended.
Lordship.
You may have a right to recovery,
Yes, Lordship.
but right to recovery through litigation is extinguished. Your right to sue does not survive. iPad. A more contractual level case. Yes, do you have any Supreme Court judgment regarding contractual liability? Admission. Supreme Court. 2018, it has been reiterated again.
Yes. It was 16th judgment, 16 judgment days, one judgment. Lordship.
2016, 17 or 18.
Yes.
2 letter. Okay, right. Mr. N. Mojuish, Learned Counsel for the petitioner, and Mr. K.
No,
N. Angami. Learned government advocate. for all the respondents. Full stop. The petitioner has instituted the instant writ petition. Please take your seat. Can you give my mobile also? Yes, later, contractual liability. Really? In Article 226 of the Constitution of India, seeking inter alia direction to the respondent authorities to disburse an amount, a sum of rupees 68,23,000 on the ground that the said amount has remained outstanding and payable by the respondents, state respondents, in respect of a contract work executed by the petitioner on behalf of the state respondents. Post of para. The petitioner has stated that he is a Class 1 contractor registered under the Nagaland Public Works Department. Full stop. Petitioner has further stated that he was allotted a contract work, quote unquote, page 16, integrated tourist travel circuit at Aboy, Sao Hachi Ing New, Sanglang Jakpang, Sanglang Su, Sangyang New. Within bracket contract work by an work order dated 10/2/2024, issued under the hand of the additional director within bracket CSS, Directorate of Tourism, Government of Nagaland. Full stop. As per the work order, the contract work was allotted to the petitioner at 30% above SOR, 2010 NPWD for an amount of rupees 57,24,000. It is the further case of the petitioner that the time period allotted for completion of the contract work was 18 months. How many work orders?
3 work orders.
3 or 4?
Yes. In the first written
Oh,
petition,
work
there are
orders.
3 work orders.
I'll equally good. 3 other work
Oh,
orders.
4 work orders.
3 other work. প্রথম লিখার বিষয়।
4.
3 other work orders,
Second day.
comma, all dated 10/2/2014 were also issued in favor of the petitioner for 3 other contract works of same nature. Post up. That amount to 68,000 to Nalaga Agohit. It is a further case of the petitioner that the time period to allowed for completion of the 4 contract works was 18 months. Post up. The petitioner has asserted that on receipt of the work orders, comma, he started executing the contract works, and after completion of the contract works, comma, the same were verified stroke inspected by the village council of Chauha Singh New, para 6. Full stop. And the same village council had issued a certificate on 9/12/2024, certifying that the contract works had been duly executed by the petitioner. Full stop. Para. The petitioner has projected that the total amount of works, total worth of the contract works was rupees 68,23,000. Full stop. Though the petitioner approached the respondent authorities for issuance of the completion certificates, comma, hence the writ petition seeking the relief, comma, mentioned above. Full stop. Mr. Angamilan, State Council, appearing for the respondents, has extensively referred to the statements and averments made in the affidavit in opposition, and has submitted that a village council is not a competent authority for issuance of a completion certificate in respect of a contract work awarded to a contractor by the state masonry, by the state of Nagaland, on behalf of the state of Nagaland. Full stop. He has contended that the petitioner never brought the fact of completion of the contract works to the knowledge of the respondent authorities. To verify the completion of the contract works to issue any completion certificate. Full stop. Moreover, the petitioner any representation on board? Okay.
Lordship, yes.
The petitioner, if the petitioner had completed the contract works within a period of time period of 18 months
18 months.
after award of the contract works on 10/2/2014. The petitioner has failed to explain the delay in approaching the court. Full stop. He has further submitted that since the claim of the petitioner, in a sense, a money claim, the repetition has suffered from delay and laches, as the petitioner has shown to have made a representation only on to 20/01/2025. Postman. Para. I have heard the learned counsel for the parties and also have also perused the materials on record, materials brought on record by the party through their pleadings. Full stop. Para. The petitioner has annexed copies of 4 work orders, all dated 10/4/2014, wherefrom it is discernible that the petitioner was awarded 4 contract works for execution. Full stop. As per the statement of the petitioner himself, he had executed the contract works within a time period of 18 months from 10/2/2024. Full stop. The claim of the petitioner is for a sum of rupees 68,23,000 against the contract work he has claimed to have executed. Full stop. Since the contract works were awarded by the Directorate of Tourism, Government of Nagaland, it is the Directorate of Tourism, Government of Nagaland who had to verify the contract works for reaching a satisfaction that the contract works had been executed duly in terms of the work order and the contract agreements signed between the parties. Full stop. The work orders, dated 10/2/2014, had stipulated that the contractor had to execute a contract works within 10 days therefrom. And the contract works were to be executed as per the drawings, specifications, etc., decided by the respondent authorities. Full stop. If, full stop, a village council was not involved either in awarding the contract works or in making disbursement of the the contract amount. Full stop. The village council is clearly an extra departmental authority who could not have the jurisdiction authority to issue any completion certificate. Full stop. Except a bold statement, BALD statement, that the petitioner was approaching the respondent authorities for release of his contractual amounts. The petitioner has not been able to brought any documented evidence to indicate that he had submitted representations during the period immediately after alleged completion of the contract works till 20/01/2025. Post up. In any matter of the view of para. In State of Madhya Pradesh and another versus Bhailal Bhai, comma, so and so. The Honorable Supreme Court has observed comma, while observing that the laws of limitation do not as such apply to the granting of relief under Article 226 of the Constitution, comma, the court should keep in mind the maximum period fixed by the legislature for granting relief of recovery of money by a suit in a civil suit. Full stop. It has been observed that the time within which a relief by a suit in a civil court is to be brought, comma, may ordinarily be taken to be a reasonable standard by which delay in seeking remedy under Article 226 of the Constitution of India can be measured. Full stop. When the delay is more than the said period, comma, it would be proper for the court to hold that it is unreasonable. Full stop. The period of limitation prescribed for recovery of money under the Limitation Act is 3 years. Full stop. Para. The petitioner herein is a class 1 contractor. Therefore, comma, it cannot be assumed that the petitioner is not aware of his rights of recovery of any amount. Full stop. The so I have forgotten Likita one. No. Having gone through the statements and affirmations made in the affidavit in opposition of the state respondents, comma, it does not emerge that the state respondents have admitted its liability. Full stop. The state respondents have asserted that the completion of the contract works were never verified by them. Full stop. Any admission of liability is to be made essentially within the period of limitation as prescribed by the laws of limitation. Full stop. Any admission of liability beyond the period of limitation, comma, as per Section 18 of the Limitation Act 1963, does not extend the period of limitation. Full stop. It is also settled that filing of representations, filing of repeated representations also does not extend the period of limitation. Full stop. As the very issue regarding completion of the contract works falls in comes within false completion of contract works falls within disputed category, comma, this court, in view of the regions already mentioned here in above, comma, finds that apart from finds that the repetition has suffered from delay and laches on the part of the petition. In such view of the matter, the repetition is found to be lacking in merits and therefore is dismissed.
Obliged.
I'll refer one judgment I have forgotten now,
Lordship.
that admission of liability is a must.
Lordship.
Lordship.
Do you remember?
No, Lordship, I don't remember that one.
Yes, hello, Paul, or something.
Similar order in the next item, 18.
Similar?
Yes.
Dismiss it.
Except, yes.
Come on.
Covered case?
Yes. Except
18.
that work order is same,
Uh-huh.
but the work is different in a different location and the contractor is different.
Petitioner is different.
Yes.
So both of them waited.
Yes.
Huh? Is class 1 or class 2?
This is a class 1 lordship.
Yes, in case we say service method, payment, recovery, and land acquisition method, poor illiterate person,
Lordship.
we sometimes use the discussion,
Lordship.
but not in case of class 1 contractor.
Lordship. Eventually, everyone becomes a class 1 contractor.
No, poor illiterate is a thing, one thing, widow, illiterate person, rustic villager is another thing.
Yes.
And he knows, contractor knows how to extract,
Lordship.
recover the money.
Correct.
So let him give this for the welfare of the state. Both of them. Right? Class 1 contractor.
Lordship, the fact remains, they are not denying the liability that I have done the work. That we have been informed.
Why you did not get it from their authorities? Why you have approached the village council?
No, Lordship, they were refusing. They refused. In spite of repeated, Lordship.
Civil suit within 3 years.
Yes.
Because it is when it is a disputed question of fact, no repetition.
Yes. In fact,
When they, as soon as they denied, you should have filed a
Correct.
Lordship.
Correct.
civil suit.
Lordship, here the system is like you'll get it, you have to wait for some time.
Right, but so far as class 1 contractor,
Lordship.
we are not. We cannot be lenient.
Lordship.
Anyway, he will get it from some other contractor.
Oblige, your Lordship.
Deeply obliged.
For orders, item number 24.
24. Is this? Oh, wow. Aye. Yes, 24. Louis come. Affidavit in reply. Filed.
Yes, Your Lordship, we filed.
You filed?
Yes, Your Lordship.
Yes.
Lordship, we've received it this morning. So if the matter may come up after 4 weeks.
4 weeks.
Yes, Your Lordship.
This IS is for what?
Your Lordship, for issuance of.
47, Rule 29, when we issue a local investigation.
Your Lordship, for appointment of a commission.
Miss
Ruling.
Rowley,
Yes.
learned counsel for the applicant appellant. And Miss
And solo for the private respondent one.
Anne Solo for the
Opposite party one.
opposite party. Number
1.
1, that's respondent. Are present, full stop. Miss So-and-so, learned counsel for the applicant appellant has submitted that an affidavit in reply has already been filed today
Yes, Your Lordship.
by serving a copy to Miss So-and-so, learned counsel for the opposite party, that's respondent, full stop. A joint prayer has been made to release the case after 4 weeks. Full stop. The prayer is allowed, release the case after 4 weeks.
Much obliged.
For orders, item number 25.
Some prayer was made. Morning,
Yes, Lordship.
you made a prayer for
On behalf of M. Longkumar, Lordship.
and Long Kumar
Yes, Lordship.
for issuance of writ, order of appointment. Landowner. Landowner.
Yes. Yes, my lord.
Okay. Who has been appointed? Respondent number 6. Service is not complete. So if you want your repetition to be allowed, his presence is necessary, or at least service is necessary. Heard, Mr.
Lelam Thong Phim Chongar.
Learned counsel for the petitioner and Miss Chang, learned government advocate, on behalf of Mr. N. Longkumar,
M. Nongkumar.
Learned State Council. First of peruse the office note dated 31. Peruse the office note. Office notes. Office note dated 17/9/2025. First of, as part of office note, comma, the report as regards service of notice upon the respondent number 6 is awaited. First of, as Sang, Ms. Sang has submitted that the necessary instructions to file the counter affidavit on behalf of the state respondents have not yet been received and has thus paid for 4 weeks' time to file counter affidavit on behalf of the state respondents. First of, await for a service report in respect of the respondent number 6. First of, the prayer made on behalf of the state respondents is allowed. First of, release the case after 4 weeks.
Much obliged.
You apply.
For orders, item number 26.
None has appeared. Either for the petitioner or for the respondent number 1, comma, Union of India, today on call. First of, as per office note dated, while issuing notices to the respondents, comma, by order dated 14/8/2025, comma, the petitioner was directed to take steps for service of notice upon the respondent number 2, 3, and 4. By registered post with AD within 7 days from 14/8/2025. Full stop. The notice was made returnable by 4 weeks. Full stop. When the writ petition was listed on 29/7/2025, none appeared for the petitioner on that day. Full stop. Para. Office note dated 17/9/2025 reflects that no steps have been taken by the petitioner for service of notice upon the respondent number 2, 3, and 4 till date. Full stop. It is noticed that in the cause list, the name of the names of the learned counsel for the petitioners are not reflected. Full stop. Para. Lease the case again on Thursday, reflecting the names of the learned counsel for the petitioners. Namely, Mr. O. Keats, Mr. A. Borua, and Mr. or Miss A.Y., I don't know. Mr. and Mrs. Badio, Otoli Keats, A. Borua, O. Keats, A. Borua, and A.Y. Sumi in the petitioner's side in the cause list. First off, it is observed that in the event, none appears on behalf of the petitioner on so and so Thursday. The court may pass appropriate orders on so and so. Court might consider dismissal of the writ petition for non-prosecution.
For orders, item number 27.
Yeah, please. Lordship.
Yes.
Lordship, in this case, I have been newly included as the counsel for the petitioner number 2, 3, 14, 24, 31, and 34, Your Lordship. So if I may be allowed 3 days, Your Lordship, to file an IA for.
This is the IA. Or what is your IA? Huh? What is your IA?
My IA
Is for what purpose?
here, the learned counsel is submitting before the Honorable Court. He's representing 6 petitioners. They want to withdraw from this case as petitioners. That is one aspect that I will submit before.
And what is the IA for?
My Lordship, my eye is that here in this case, I am only on the issue whether a person can be given regularization, seniority prior to their appointment. That is my only issue before the Honorable Court. And I have filed this IA, that is, I have the publication in the newspaper, Lordship, that is publication as well as
in urgent notice.
I was allowed to publish in 2 local dailies the names of the respondents. I am for the petitioners. And there are 171 respondents.
No. What is the case about first?
The case is, Lordship.
These petitioners, how many? 52. Yes.
Yes, Lordship.
Namely, so and so.
Now-
Appointed graduate teachers trained between so and so are agreed mainly with the seniority list of 27/9/2022. If it is a case of seniority list of 2022, why you have approached after 3 years?
Lordship, in 2000, after issuance of this seniority list, we have been submitting multiples of representation, but they issued a
Whether
tentative.
this seniority list was the final seniority list?
Yes, now we
And-
are preparing for issuance of final seniority
No,
list.
this is provisional or final?
This is a final.
Twenties-
Kindly come to 263.
Because final seniority list is preceded by a provisional seniority list,
Yes,
inviting objections.
that is already done. In March, tentative seniority list was issued, Lordship,
Where is the seniority list you are impugning?
63, Lordship.
263.
Yes.
263.
Yes, this is.
Where
the
is the forwarding letter?
Lordship will kindly,
Graduate.
Graduate teacher,
Okay,
graduate.
page 262.
yes,
And
Lordship.
it was preceded by any provisional seniority list,
Tentative seniority list was issued
Ah.
prior to this,
inviting objections.
inviting objection.
Then
That tentative seniority list, Lordship, I pray that our name and the respondent's name was not included.
not
in the tentative
included.
seniority list.
Tentative.
In the tentative prior
Okay.
to,
Okay.
prior to issue. Now,
Then this was published in September 2022.
22, that is the final.
Then
seniority
you
list.
objected to it. You objected to it.
Yes, Lordship, we submitted several representation.
Okay.
And in March 2025, they issued a tentative seniority list. In spite of our submissions, several representations.
Okay.
And also
Again,
next-
March 2025.
Yeah,
They have
they issued a tentative
tentative
list.
seniority list. Where is the?
Where both the petitioners as well as the
Where is the
respondent were
comment
not
letter?
included
So
in the
there,
tentative seniority list.
in the tentative seniority list, the petitioners' names are included or not?
Not included.
Not included.
Not included the petitioners as well as the present respondents.
Okay.
Both the side,
They were not. They are not included.
they were not included. Here what
Okay.
has happened is, Lordship,
Hmm.
in the respondents were appointed in two batches. That is on 28/8/2012, a batch of respondents. Then on 31/7/2015, two batches, the respondents were appointed. And prior to their appointment, the cabinet took a decision and regularized them retrospectively on 1/4/2012 before their appointment. That's why we are only on that. Whether the legality, Lordship, whether an employee can be given regularization, obliques, seniority. Now the seniority that I'm changing. Seniority retrospectively prior to their appointment. That is the only issue before this honorable court. Now what has happened is, Lordship,
1 minute. Then you submitted on earlier that the seniority list which has been impugned. In this writ petition, the position of the private respondents were shown above the present petitioners.
yes, Lordship. That is my only issue.
In which one? Which one? Because in the new one, say your names are not included.
In the tentative seniority list, issued in March. This year.
You said that your names were not included.
Yes, that's why.
Then how this submission?
But
That your positions are below private respondents.
I have.
You have submitted just a few minutes before me.
Yes, I have included the preparation of the final seniority list, although it has not been published, Lordship. We can kindly come to page.
No. First the writ petition. Let me understand the case, then I can understand the I.
Lordship.
You said on 27/9/2022, a seniority list was published.
Yes, graduate teachers, Lordship. As on 1/11/2022.
Yes.
Yes.
In that seniority list, what is your grievance?
My grievances is that the petitioners were appointed after the respondents were appointed after the petitioners. But they were placed above the petitioners,
So you
52 petitioners.
you started submitting objection.
Yes, Lordship.
Then in March 2025, another tentative
Seniority
seniority
list
list was published.
Exactly.
And
Lordship.
therein, your names are not included.
Included,
Included,
not included,
not included.
as well as the present respondent.
Right.
Also. Both sides were
So
not included.
why you have challenged this tentative seniority list? Because of your non-inclusion.
No, I'm not challenging the tentative seniority list. I am, Lordship will kindly come to the last one. This is a preparation of final seniority list that is to come
minute,
out
okay.
at any time. Annexure K1.
Petition submits that on 20/03, prepare a tentative seniority list. Submits a petition appoint that in the final list. And we again on the basis of ages from below considered by the. Okay, now why this I?
This IA is.
So
because-
final seniority list on the basis of this tentative seniority list has not yet been published.
Not published.
Okay,
They are under
Now why I-
preparation. Anytime to be published.
why I?
Now, Lordship, what has happened is, my lord will kindly come to just because petitioners approach this honorable court, the 52, now 6 wants to withdraw, so that will come to 46, right? 46 before this honorable court. If the 6 of them withdraw from the petitioners list. Now,
What if
Lord,
they have to file an application?
yes, they will. They are
Yes.
under preparation.
Now, why?
What has happened is, Lordship. Can I submit?
Yes, please.
Yes, Lordship. What has happened is, it has become very personal. And since the 52, now 46 petitioners filed this case, a campaign like has been instituted, and Lordship, they have started saying, I'm only on I'm declaring before this honorable court, and my lord, my submission may be recorded also. And in my IA also, I am placing before this honorable court. What has happened is, there is a propaganda going on that I am challenging the appointment order of the respondents to terminate them from service, when that is not even in the writ petition, Lordship. Some are misleading, Lordship, and now that was the commotion. And
Madam,
Yes,
we are only on the issue brought on record.
yes, Lordship.
We are not on any issue of propaganda, protest everywhere. We don't know about that.
Yes. Lordship will
So
kindly
if-
come to page 37 of
This is the purpose of the IA
IA.
37.
Yes, this,
How 37?
the original is at page
How 37?
37, annexure 3. It is type out, Lordship. The type out copy is at page 37. This is the RTI that was filed on 10/9/2025. Allow me to read out, Lordship. To the Public Information Officer, Office of the Directorate of School Education, Kohima, Nagaland.
Who has filed this? Who has filed this?
This one, I just now received the last page from my WhatsApp, Lordship, because it was issued on Friday, so we could not procure it. And since it was Saturday and Sunday, Saturday was holiday, and yesterday was, so
Okay.
only today they went and they procured it. But I tried to print it out before I place.
Okay, please read.
So it is now with me. To the Public Information Officer, Office of the Directorate of Kohima, Nagaland. Subject: an application under Section 6 of the Right to Information Act 2005, seeking for information. Respected Sir, Madam, kindly furnish the information which are set out in queries number 1 to 8. 1. Whether the teachers appearing in serial number 1 to 47, that is the petitioners now, below, were appointed against the sanction post. If yes, kindly provide the details and list of the teachers are enclosed as annexure A. 2. Whether the appointment of the said 47 teachers were made by conducting recruitment examinations, and whether the posts of the said 47 teachers were advertised prior to conducting recruitment drive. If yes, kindly furnish the details of the advertisement notification, examination details, etc. 3. Appointment orders. 4. regularization orders. 5. Education qualification of the said 47 teachers from matriculation to degree and B.Ed. Kindly furnish the photocopies of the certificate of educational qualification of the said 47 teachers. 4. Whether the graduate teacher appearing at serial number 38, i.e. Sri Tovi MGHS Puhuboto Dimapur, is an indigenous inhabitant of Nagaland. If yes, kindly furnish the indigenous certificate of Sri M. Tovi GHS Kuhuboto. 7. Whether the graduate teachers appearing at serial number 12, i.e. Sri Vihaputi Sema GHS Dipupar B, Dimapur, was appointed against the sanction post, whether a vacancy can arise when the post of Srimati Kitoshi Zetsu, graduate teacher, was converted to SIS under DEO Dimapur. I state that the information sought about does not fall under Section 4 of the RTI Act 2005. Now, Lordship, we kindly come to page 38. The typed copy is at page 38A. This is now the 47 prison petitioners who are before this honorable court, Lordship. So these are the RTI application to furnish the documents. In pursuant to this, Lordship, my Lord will kindly come to page 39, Annexure 4. This was issued on 19th, that is on Friday, Lordship. Urgent notice dated Kohima the 19th September 2025. This is to inform the undermentioned respective district controlling officers, DEO Dimapur, DEO Kohima, DEO Zneboto, SDEO. Lordship, DEO is District Education Officer, and SDEO is Subdivisional Education Officer. Dimapur, SDEO Peren, SDEO Chozuba, SDEO Poboto, SDEO Atoize, SDEO Zneboto, SDEO Medzipima. Under this are the petitioner under this SDOs and DEOs to take immediate necessary action in notifying the teachers serving under their establishment to furnish the required document listed in Annexure 2 without delay to their respective district offices for timely submission to the Directorate Office. The list of concerned teachers along with their details is enclosed in Annexure 1. Last date for submission to the Directorate Office is 24/9/2025. This directive must be treated as priority. That will expire day after. Today is 22, Lodge. Now, my Lord, Annexure 1, page 40. These are the names of the present petitioners. Lordship has seen it. And the Annexure 2, page 41.
Yes.
These are the checklist that is immediately being asked from the respective district officers to submit prior before 24th.
So this proceeding is under the Right to Information Act.
Yes, Lordship.
The application was submitted to the State Public Information Officer, SPIO, right?
Yeah.
Then that was processed and this principal director has passed this order,
Yes.
right? And now the information so far is, if you look at page 37A, 1, 2, 3, all this 1, 2 essentially 1, 2 essentially falls within public information.
Yes, Lordship.
1 and 2. And this educational qualification, all this,
Yes.
I think Roman 5, that is relatable to page 41, right?
Exactly.
If you feel if you feel this is an information which is not required to be provided to the applicant, the RTI applicant,
Lordship.
you invoke section 8 before the authority, not before us.
Lordship, I
Right
have
to
not,
Information Act.
I have not.
If you feel these information at page 41 falls in the category of personal information,
Lordship,
which
exactly.
should not, please hear me out, which should not be disclosed, then that objection, since you are aware, then that objection has to be raised before the SPIO, not before a read court.
Lordship,
We don't know for what reason somebody has rightly exercised the right. Nobody can stop an applicant to seek information under the Right to Information Act.
Lordship.
Now, if it is public information, that has to be disclosed. But there is an
Yes,
exception.
yes, exactly.
If it falls within personal information and prohibited category,
Lordship.
then the authority should not disclose it unless
Lordship.
a notice
Lordship.
is given to the person
Lordship.
whose personal information is going to be disclosed. Since you know now, 24 is the last date,
Yes.
you exercise that right before SPIO, come to 8. But I still feel this is an appointment to a public post. Whether this page 41 information will fall in the category of public confidential information.
Lordship.
Let us see 8.
8(1)
Exemption.
Exemption.
Let us see. Law has been settled. Show me that this cannot be disclosed.
Yes.
Show me.
8(1)J, Lordship.
Yes,
Page 11, Lordship.
8(1)J only.
J. May I read out, Lordship?
Hmm.
Information which relates to personal information, the disclosure of which has no relationship to any public activities or interest, or which would cause unwanted invasion of
What? Which one? Information which relates to personal information.
personal information.
That's
Lordship.
all.
Here my
Don't add anything. Information which relates to personal
personal
information.
Yeah, exactly, Lordship.
And thereafter,
Thereafter, unwarranted
which one you are reading?
J, Lordship.
Huh?
Clause 8, subclause 1J. Mine is a different book, Lordship. However, J.
This
if
is
my-
2024 only. Barracks.
If my lord could kindly come to 8,
When is your
8(1).
when is your
This one is
published?
the Nagaland Information Commission. This is
Madam, J has been amended in 2023.
2000. This is 2005, Lordship.
That has been amended. J has been amended. That part what you are reading,
Yes.
which has no relationship to any public activity or interest, that is gone. That has been deleted.
Lordship.
You are reading an old book.
Can I have,
See,
with the permission of my lordship?
please.
It doesn't come that much. So
All are gone, which you are reading.
this will be
I have opened the page.
lordship.
8(1)J.
8(1).
J. Read what is there?
J.
Small one.
Yes, J.
Ah.
Information which relates to personal information.
See the note below.
Provided
No,
that
see the note below at the bottom.
not.
When it is amended,
This is on 23rd, 2023.
2023.
2023, Lord.
this application is of 2025.
Lordship.
So 81J is presently, as it presently stands.
As it stands.
Apply,
As it stands.
right?
Yes, Lordship.
And all these other are gone.
Lordship.
Now the question is, this is a public recruitment process. Whether this page 41 information is public or private, law has been settled.
Lordship.
And forum to raise any objection is the SPIO
SDEO.
and the appellate authority,
Yes.
not before a constitutional court.
My humble submission before the Honorable Court, Lordship, just one submission. I approached this Honorable Court just on an emergency basis because the impugned order that was issued by the Principal Director, Lordship, that was not as per the RTI Act. The RTI application was submitted on 10/9/2007. Immediately, and RTI Act is applicable to public authority, organization, etc. Lordship. My lord, in your wisdom knows. Now,
This man,
when it was submitted to the PIO, it has to be the department, if at all, it has to be they who ought to have furnished the documents.
now
But
let us have the,
asking
who is SPIO?
sub
Every office has to have a SPIO, state
Here-
public
information.
information office.
Yes. Lordship.
That designation does not mean he is from the government. Directorate should also have, his designation is SPIO. Every office, even deputy
Yes,
commissioner,
yes, Lordship.
even in the, if we go to the deputy commissioner
Yes,
office,
Lordship.
his designation is SPIO. Essentially, he is public information officer for that office.
Lordship.
Now, here the application is public information officer, office of the Directorate of Education. And in the Directorate of Education, principal director is the main person.
Principal Director is the FAA.
Main person in the directorate. Above him, secretary is there in
Lordship.
the department, in the government. But
Lordship.
for the directorate, he is the main person. And
Yes.
he has authorized the SPA to give the information.
Lordship, he is the, as per the RTI Act, he is the first appellate authority. He is,
But the information, it is his PIO. It is his
Lordship.
PIO. No, otherwise, your remedy does not lie before the constitutional. Your remedy lies before the forum under the RTI
Lordship.
Act. And
We
you are,
were
what you are seeking, we are not inclined. You want the stay of that.
Just to suspend so that it will be expiring day after tomorrow. That was to
You file,
submit.
you have 2 days. Today is only Monday, Tuesday, Wednesday. You file an application seeking prohibition or disclosure, restraint of the disclosure of the information, saying that it is your confidential and private information.
Yes, yes,
It falls in the category.
Lordship.
He's-
We will be taking that step, but just.
But here I am dismissing it. Giving the liberty. Because you have the forum to agitate this.
Lordship, that
It
is.
is not the forum.
Just a few, some petitioners are also not in station also, and some are facing difficulties. So it's just that since it is expiring day after, that is on 24th, just that is the only limitation for approaching my lordship.
When there is a will, there is a way.
No, petitioners, some petitioners are out of station, that are also some difficulties.
That is a different issue, or at least if the broad issue is that this kind of information are not required to be disclosed because it falls in the category of confidential information,
Yeah,
right? Then 10 petitioners will be enough, even if 20 petitioners are out of station.
of course.
But
Uh,
Constitutional Court is not going to.
no, I leave to your lordship's wisdom, lordship.
Exercise our power of judicial review in such matters.
Lordship.
You have 2 days' time. 10 of them goes satisfied that this falls in the category of confidential information and not to be disclosed to an applicant. Show them the law, argue the matter. We'll observe that personal hearing should be given.
To the petitioners. Lordship, my lord, this honorable court has an inherent power. It's just that
We know
I have
inherent
approached-
power.
Yes, I am just approaching this honorable court just for some few days privilege to the petitioners.
What is
at
the
least for-
problem? What is the problem? If
For-
you're legitimately appointed, you have all the qualifications,
Of course, lordship,
right?
of course, lordship.
Claiming seniority. What is the problem then from disclosure of your information? Something
No, no,
is
we will, lordship.
something is not right, perhaps.
No. It was issued on Friday evening, we got it, lordship. Saturday was
If
holiday.
you are clean, they need only your matriculation certificate, higher secondary certificate, graduation certificate, blah, 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 all your education qualification. If you have the qualification to be appointed as a graduate teacher, what is the problem for you? You should have said that, no, why you are going to public information which we are giving you free of cost.
Lordship, it will say president and.
I'll come back. I'll come back.
Lordship. Lordship,
1 minute.
this is the second page.
RTI Act. Can you pass on the RTI Act?
Just my lordship.
Madam,
Lordship,
81J is there, plus 82 is there,
lordship,
82.
lordship.
82 is that notwithstanding anything, right? A public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest, right? He may have exercised this power, right? Otherwise, Section 11 says, if it is third-party information, a notice is to be sent to the
Lodge.
person concerned,
Lodge.
right?
Lodge.
Then Section 19 says, any person who is aggrieved by a decision of the State Public Information Officer, as the case may be, may within 30 days from the expiry of such period can prefer an appeal. Right.
Lodge.
What we can do maximum, because your right of appeal is there against the decision to disclose the information. Right. So
That I will pursue. I'll take
that you will approach.
I will.
Right.
Lordship,
So within a period of 30 days, you can prefer an appeal. before the first appellate authority.
Of course.
That will be, I think, government secretary.
Lordship, it will first have to go through PIO, state SPIO.
Oh, no, state, the state SPIO means everybody is state SPIO. But first appellate
Here
authority,
in
first.
every department,
No.
in every department in Nagaland,
Uh,
a state PIO is appointed.
Yes.
One
yes,
state PIO.
yes, this is a PIO, SPIO in a directorate. Here we are concerned with SPIO in the directorate.
In the directorate.
And the next appellate authority is SPIO in the department, government. Do you have education department or what is
In
department?
education department, Lordship, what within my knowledge, PIO,
Yes, ma'am.
PIO is the public information officer is there in the directorate. Then if the PIO fail to furnish the records, then it has to go before the first appellate authority, that is the prison principal director. That is the sequence. So just my humble submission before this honorable court, Lordship.
Not that much, I'm not very satisfied.
Just my,
Because
that is
First-
what is
first-
practice at present,
first appellate authority
is the HOD.
is the government. HOD is no. First appellate authority will be the government. Section 19. Then second appellate authority is the information commission.
Information commission, Lordship.
So it is always the government. Because it is to such an officer who is senior in rank. 19(1).
In the director, there is a director. In-
Principal director is the main.
Yes, there is a director in the directorate. Next is the principal director. Just my humble submission before this honorable court, Lordship. Just one request.
Who is the first
Since-
appellate authority? Madam, state. Who is the state? Who is for the state? Who is the first appellate authority? Government. This directorate is under which department?
School education department.
School education department, so it is the secretary there. Will be the first appellate authority. Thereafter, it is the State Information Commission, if it
Yes.
exists here.
Yes, yes.
It exists. State Information.
Yes,
Second appeal
we
is
have
there.
appeared many times.
So what I propose that since this order appears to be under section 8(2), notwithstanding, he invoked the notwithstanding, non-obstante clause and has decided to disclose the information. You have a right to appeal before the first appellate authority.
Lordship.
To my understanding, it is the government who is the first appellate authority. You get the instruction?
At two,
Yes. Then we can only observe that you.
because
since
there
you-
is a confusion,
Since you have the right to appeal before the first appellate authority
Lordship.
and
I will do that, I will do.
if the first appellate authority is the government, then you should prefer the appeal before the first appellate authority.
Whether
And till that time, no, subject to the decision taken by the first appellate authority, the information directed to be disclosed by the principal director is
Lodge.
not to be disclosed.
Lordship.
For you to exercise the right to first appeal. That much I can give.
Lordship, I will be very.
But I will not make any observation on merits.
Yes, Lordship.
Should not.
Merit, it will come later on, Lordship. I humbly obliged.
First appellate authority, find out if it is the government. Madam is saying it is principal director. I don't think he cannot sit in appeal. He cannot sit in appeal over his own judgment. He has
Yes,
taken a decision.
That's why to
I
my.
have said, that is why I am saying that he cannot sit in appeal over his own decision. That is also not permissible under law.
That's
Am I correct?
Just a little confusion here, Lordship. I get to know that first appellate authority is the principal director and some RTI previously. First appeal was appeared before
Madam
the.
is taking instruction.
Yes.
Let her take instruction.
Yes. That
As soon as possible. Don't wait up to 2. Go out, make a call. Who is the first appellate authority?
Lordship.
Next.
For orders, item number 28.
Who submitted, there is no notification yet published in respect of shortlisted credit taking. What is the issue about? Why it has come for orders?
Lordship, some of the respondents hearing the notice upon some of the respondents are yet to be completed, my lord.
That's right.
Yes, Your Lordship. I'm representing 1, 2, and 5, my lord.
1, 2, and 5.
Yes, my lord.
There are 24, 28 petitions. 1, 2,
And 5.
5.
3 is the state commissioner for person with disability and the state mission director.
Rehabilitation Council of India, this is an independent body.
Yes.
It has to be served.
Yes.
And 6 you cannot represent.
No, Your Lordship. Because it's a mission.
3 and 6, not you cannot represent.
No, I cannot represent.
So you have taken steps.
Yes, Lordship.
Service is awaited, 3, 4, and 6. Yes.
Yes,
We have to wait then.
Lordship.
Anything?
Lordship, on the last occasion, also a direction was also issued to the state respondents.
Okay.
To file an affidavit by.
Let me read.
17th of September.
Nangami. Senior who submitted, there is no notification yet published in respect of shortlisted candidate, taking into account that there is a further possible verification going on. The further submits that to the eligibility criteria for appearing in the screening test have been put at the same is required for the students. What are the other 2 categories?
Your Lordship, the.
Let me read the first order, then I'll understand. Addition. Contractual special education teacher.
Yes, Lord.
These special education teachers
Lordship.
are to be, posts are to be sanctioned,
Lordship.
right?
Yes.
Posts are to be sanctioned.
Yes.
Then after posts are sanctioned, then state has to issue an advertisement.
Yes.
Okay, then thirdly, the selection and appointment of qualified eligible teachers have to be made.
Yes.
Lordship.
Requirement of RCI. What is RCI certificate?
Rehabilitation Council of India, Lordship. We have
For appointment of the post. So these teachers are to be what? They have to have the qualification,
Yes.
or they are not persons with special disability.
No, Lordship.
No, okay.
They teach the.
They are normal. They can be normal person.
Yes, Lordship.
Okay. What is the appointment? Then those who have already been appointed on contractual basis,
Lordship.
there has to be a screening process.
Exactly.
Right?
Yes, Lordship.
Now, what are these petitioners? They are already appointed on contractual basis.
Yes, Lordship. Yes, Lordship.
Okay. You have the RCI registration.
Yes.
And diploma in education. Right, but this is number of posts or sanction. So you are employed where? Preschool, nursery, elementary, upper primary school.
Yes, Lordship.
You are appointed
Yes, Lordship.
in this category of
Yes.
schools. Okay, and there you say that there you need only diploma in education,
Lordship.
not B.Ed.
No, Lordship. Yes.
So what the state has advertised is with B.Ed qualification.
Yes, Lordship.
Yes,
They
exactly.
Right.
B.Ed qualified,
Yes.
qualified teachers, they teach only the higher
Higher.
level of
Okay.
education.
So diploma in education, according to you, in the other two category, the
Yes, Lordship.
below high school,
Yes, Lordship.
upper primary school or primary school,
Yes, Lord.
or say preschool or nursery play school, B.Ed is not the requirement,
Lordship.
according to you.
Yes, Lord.
And you are also contractual teachers already,
Yes, Lord.
imparting education to children of with special needs.
Yes, Lord.
Yes.
Not sure what has happened on
Huh.
August 2025, the state they have published a notification.
That I have read.
Yes.
Huh. That from that it transpires that they are seeking applications only from candidates
Yet qualified.
with B.Ed qualification. So Mr. Angami was directed to obtain instruction.
Yes, yes, Your Lordship.
Whether the state is contemplating for
Speaking of even
other category, other two
Correct.
categories,
correct,
right?
correct, Your Lordship.
And dispensing with the requirement of B.Ed.
Yes.
Yes. What is your instruction?
Your Lordship, in fact, on the last occasion, I have placed the instruction also. See, my Lord have already seen there are three categories. There are three categories of teachers here. The post that has been advertised relates to the category.
Where is that advertisement?
Lordship, the advertisement, Your Lordship will find it at page. No, advertisement.
Page 121.
121, Your Lordship. 121, Annexure 6. If you see this, Your Lordship, this relates to teachers in respect of, Your Lordship, the secondary and higher secondary and senior secondary.
Where from we can see?
Your Lordship, at page 126 is the qualification prescribed. Page 126, my Lord.
Okay.
Yes, is the qualification prescribed for secondary and senior secondary.
Okay, there are two categories. As per this is a
The
Rehabilitation
categories.
Council. Rehabilitation
Yes.
Council.
Yeah,
Okay.
there are three categories.
Okay, let us see 125.
Yes.
Yes, Lord.
10
So,
pass,
yeah.
10 pass, 12 pass, 12 pass 1-year diploma program in early childhood special education.
Yes.
Do you have diploma in special education?
Yes, Lord.
Oh, you have?
Yes, Lord. All the petitioners, Lord.
Okay, then this is the requirement.
Yeah, this is the requirement. This is a requirement. Now, your lordship, the advertisement, the notifications,
This advertisement includes
yes,
whether this advertisement page 121, applications are hereby invited from contractual special education teachers
yes,
currently employed.
yes,
You are employed under Samagro Hikha. Then for if Samagro Hikha includes the other category of schools, then there the screening
yes,
has to be done as per the qualification of the Rehabilitation Council of India, perhaps.
yes,
I have not read the entire document or the judgment,
yes.
but otherwise, prima facie it appears.
Yes. No, your lordship. This notification, it dated 8th of August 2025, relates only to one category. Relates only to one category. The government is contemplating to create more posts for these other two categories. And on the last occasion, your lordship, I have placed that. I have received this instruction. I have placed that, your lordship, but I may be allowed to place it again if.
Well, not there. What does it say?
Your lordship, that
And the Supreme Court judgment is also for the other category, two categories.
yes, yes, for all the categories, your lordship.
In fact, Lordship, your Lordship, we really appreciate there were twofold direction by the Supreme Court, Lordship, which is pending and it's coming up tomorrow also, Lordship. The first one is to conduct screening tests for those who are in service, Lordship. And the second direction is to all the states and the UTs in the country to create posts and advertise, Lordship. Two the directions.
They are party. Nagaland is a party in the Supreme Court.
Yes, Lordship. Yes.
Then
No, your lordship. For the state of Nagaland,
they will get the necessary treatment there.
yes, for the state of Nagaland, there was a relaxation made actually, your lordship. There was a relaxation made for the state of Nagaland, your lordship. But having said that, your lordship, if you see the first page, your lordship, the second para starting with in the first phase. If I may be allowed to read this too, your lordship.
Yes.
In the first phase, conversion and upgradation of 34 vacant posts under the establishment of school education to that of special education teachers in the pay level of graduate teachers, essential regular posts to teach secondary, senior secondary levels was taken up, and on approval of the cabinet, the same has been notified on 28/3/2021. Your lordship, which is there in page number 121. Screening committee has also been constituted as per the direction of the Honorable Supreme Court. An advertisement for recruitment, filling up of the post was notified on 8/8/2025. Your lordship, the next one. The second phase of conversion of 25 general primary teachers post to that of special education teachers at elementary, primary level is under process and examinations. Hence, no category of teachers as prescribed in the RCR guidelines, no Supreme Court orders will be excluded. A contract or ad hoc special teachers education possessing the requisite qualifications, fulfilling all criteria prescribed will be accommodated in due course of time. So we are converting, your lordship, to fulfill and to appoint the teachers mentioned in the other two categories, your lordship.
So, assume that your right to claim under the Supreme Court judgment is not closed.
Lord.
It seems to be deferred,
Lord.
postponed,
Yes,
postponed.
Yes.
Because they are now saying that 34 posts have been sanctioned for the contractual teachers.
Yes, for senior secondary.
For senior secondary and so and so.
Yes.
Paragraph 2 is clear. Paragraph
Yes, we are converting it.
Paragraph 3, second
Yes.
phase of how many petitions here?
28 petitioners.
They are saying 25 general primary teachers to that of special education teachers. They are going to convert.
Lord.
So, your lordship, in this writ petition, in fact, the petitioners cannot be said to be aggrieved at all because this is not the category where they can be appointed. It is particularly in the advertisement.
Advertisement note, but they can claim right under the Supreme Court direction. They need implementation of that.
Yes. We are implementing.
Yes, Lordship. In fact, Lordship, if I may be take the Lordship to the direction issued by the Supreme Court.
Yes, please.
Page 105, Lordship. This is very clear, Lordship. Page number 105 of my petition. May I read, Lordship?
Yes, please.
In spite of the judgment passed by this court on 28/10/2021, and the directions contained in the paragraph 57 of the judgment, which is reported in 2021-17 SCC 1. And then subsequently the order stated so and so, passed by this court. None of the stadium or utilities have made any appointments on the sanctioned post of technical teachers. In fact, a large majority of the states have not even identified the sanctioned post required in the state, in spite of the fact that now we have the figures in each of the state having children with special needs. The figure of children with special needs in each of the states and UTs, which we presently have before this court, which may merit present, but only slightly is as follows. What you will find in state of Nagaland,
4084.
20.
4084.
Yes, 4084. That is the post identified note, the figures identified note. In the judgment dated so and so, it was left to the central government to come with a clear teacher pupil ratio in such schools with children, special children in ratio, which we have been given by the central government. Is 1:10 for primary school and 1:15 for middle and senior schools, secondary schools respectively. Once we have the teacher pupil ratio with us and also the figures as to the number of children with special needs in each of the states and UTs by this time, each of the state and UTs should have this identified the number of sanctioned posts. Under these circumstances, the following orders are being passed today. The first direction, Roger. Each states and UTs shall come with the notification with the number of posts that have been sanctioned for teachers who have to impart education to children with special needs. 2. After the posts have been sanctioned and notified, which shall be done possibly within a period of 3 weeks from today. That is, all before 28th of March 2025. The date is very important. This post need to be advertised at least in 2 newspapers having wide circulation to the respective state as well as on the website of the Department of Education and also on the official government website of each of the states. 3. Let the selection and appointment be made of qualified, competent, eligible teachers only. Further, the requirement for RCA qualification certificate also needs to be taken into account for appointment to the post as directed by this court in this judgment dated 28/10/2021. As a candidate not having RCA certificate shall be ineligible. Meanwhile, we have informed that in many of the state and utilities, ad hoc teachers or contract teachers are presently imparting education like the present petitioner's statute. And taking classes of children with special needs. We have also been informed that in some of the states, these teachers have been continuing for the last 20 years, approximately. For these reasons, the state shall immediately consider a screening committee considering of the following. I'm concerned with this statute. The state commissioner so is one of the member, secretary of education of the concerned education department, and nominee of the RCI, who will be a competent person having knowledge in the prescribed area. This shall be the 3-member committee for each of the states and UTs. We make it very clear that the screening committee shall examine the case of each of the candidates who have been working on the teachers, children, and post teachers who have been found to be competent and qualified to teach. Shall be given the pay of scale of special teacher. The past experience.
Thereafter, matter was listed on 15/7.
Lordship.
What happened then on that day?
On the day, the state.
But anyway, in the last paragraph, Nagaland is included.
Yes.
They shall initiate the exercise. All the same, they shall initiate the exercise.
Yes.
Ah.
Lordship, may kindly come to page 109. 109. This is after, this was the matter, when the matter was listed again, thereafter. 109, Your Lordship. Last para.
I have read.
Yes.
I have read.
So, Your Lordship, we are
109, 1010, I have read.
yes, we have asked to initiate the exercise.
You
We are doing it, Your Lordship. We are doing it.
But deadline was same for all. Deadline was the same.
Lordship.
Otherwise,
However, since the difficulties was expressed, the Honorable Apex Court has taken this into consideration and
then what was the next date? 15/7.
yes.
What was the order passed then?
57 only. Another 119 Lordship. Page number 119.
The order is at page 111.
119.
Yes.
This is the order.
Start from
Yeah.
119.
Okay, 15/7.
Yes, sir.
And respect the positive defense in relation to direction contained in so have been is in breach. We call upon the 36 states mentioned in page 10 of the order dated 7 March. 7 March. this order, previous order we have read, that is the order dated
The first one is order dated 7th of March.
7th of March.
Yes.
Okay, what is there in paragraph page 10 of the said order? Page 10. Okay, this 36. To file separate affidavit pleading compliance. Then 29th August, what happened?
Lordship,
Because Chief Secretary or Additional Chief Secretary, Principal Secretary, they were directed to remain present in the event they failed to fulfill.
Lordship.
So what happened?
Time was granted to the states and the letters was on 16/9/2025. 16/9/2025. If I may be allowed to read it, Lordship. This matters are listed today for reporting compliance of the earlier directions of this court. Mr. Soito, Leonard Ambedkar has placed a chart before us summarizing the steps taken by various state government and UTs. According to him, except for a few states which have taken steps for substantially complying with the earlier directions, most of the states have faltered. Accepting the suggestion of the Americans, we propose to take up this matters for consideration once every week with focus on the steps taken by 5 states and union territories at a time, Lordship. Now, the states who have complied were Chhattisgarh, Meghalaya, Bihar, Himachal Pradesh, Jharkhand. Only the states have complied. Now the relevant direction, Lordship. The cases relating to appointment of special teachers in the state of Jharkhand, Delhi, Orissa, Punjab, and Nagaland shall be taken up on 23rd September at 3:30 p.m. Lordship. That is tomorrow, Lordship.
Tomorrow.
Lordship.
Maybe your Chief Secretary may be hold up or maybe uh, maybe given appreciation, we don't know.
In fact, the
Yes.
Honorable Apex Court contemplated even to initiate contempt proceeding against the states, Lordship.
That is why I say he may be appreciated or he may be hold up, we don't know.
That we don't know.
3:30 we'll know, but for the timing, we give a short date. We observe this, the second phase that your concern is, and they are contemplating.
Yes.
We'll
yes.
just observe, and we'll also observe that case is listed tomorrow for non-compliance. Thereafter, the order to be passed tomorrow,
Lordship.
you place it on record.
Lordship.
Then we'll go, if it is possible, we'll go hammer and tongue. Let us see what happens tomorrow. We'll await sir for the other respondents.
Yes.
Third, Mr. Moa Jamir, learned counsel for the petitioner, and Mr. N. Angami, learned senior government advocate
Yes.
for the respondent number 1, 2, and
And
5.
five.
Full stop. Peruse the office note dated 17/9/2025. Full stop. As part of office note, comma, the reports as regards service of notice upon the respondent number 3, 4, and 6 are awaited. Full stop. Para. One of the grievances of the petitioner is that the notification dated 8/8/2025 have prescribed the requisite qualifications for a contractual special education teachers currently employed under the Homogra Hikha for the purpose of screening. Postdoc. The petitioners have stated that the qualification prescribed in the advertisement are meant for only meant for special education teachers to be appointed in secondary and senior secondary schools. Full stop. The Rehabilitation Council of India has already approved the qualifications for appointment of special category, special education teachers in 3 category of schools. One, page 125 of the pre-school stroke nursery stroke play school. 2, elementary primary stroke upper primary, and 3, secondary and senior secondary. Post of para. The petitioners have stated that they have been discharging duties as special education teachers after being engaged contractually, in the first 2 category of schools since long. Full stop. The petitioners have further contended that the directions of the Honorable Supreme Court of India in Rajneesh Kumar Pandey and others versus Union of India and others are also for the first 2 category of schools. Defining, indicating therein the ratio to be followed. Ratio of teacher as people, ratio to be followed. Teacher as people ratio to be followed. Full stop. As the state respondents have not undertaken any process, or the another grievance of the petitioner is that the state respondents have not undertaken any process for the following process for the first 2 category of schools, page 107, 1, 2, and 3. When the issues were deliberated upon on 29/8/2025, Mr. Angami, as senior government advocate, was asked to obtain instructions about the steps that are being taken for the purpose of recruiting special education teachers in the first 2 category of schools. Full stop. Insofar as the petitioner's grievance that in the advertisement notification dated 8/8/2025, no, the number of posts one of the grievances, one of the grievances of the petition is that in the notification dated so and so, the number of posts were not mentioned. Full stop. In the instructions placed by Mr. Angami, within bracket marked and kept as document X. The number of posts that have been sanctioned for special education teachers and which are meant to be, which have been brought under the purview of the advertisement dated 8/8/2025 is 34. Full stop. Para. The instructions placed by Mr. Angami go to indicate that in the second phase, comma, '25 number of posts of general primary teachers would be converted to special education teachers at elementary stroke primary level. And the process is in progress. The instructions also mention that no category of teachers as prescribed in the RCI guidelines or Honorable Supreme Court's directions would be excluded. A contract stroke ad hoc special education teachers possessing requisite qualification and fulfilling all criteria prescribed would be accommodated in due course of time. Full stop. As per in office letter number so and so, dated 25 August 2025, comma, of the Principal Director, comma, the School Education, addressed to the Commissioner and Secretary to the Government of Nagaland, Department of School Education and SCIRT, Nagaland. A proposal a proposal has been forwarded for conversion of 25 number of posts of primary teachers to special education teachers. Put in bracket, primary level post. Mr. Angami has submitted that he will be able to provide up-to-date instruction regarding the conversions on the next date of this thing. Post. Mr. Jamir, Land Council for the petitioner, has submitted that the case titled Rajni Snegasla versus Wenso Chopra is to be listed tomorrow, 23/9/2025, before the Honorable Supreme Court of India. First up, list the case on so and so. After, yes, Mr. Angami. October, tell me. 17th of October? 17th? This is the case on 17th of October. Mr. Angami shall obtain up-to-date instruction as regards the proposal of conversion of 25 number of posts on the next date of listing, and Mr. Jami shall place on record the directions, if any, given by the Honorable Supreme Court of India pertaining to Nagaland in Rajni versus Lynch. Let the Chief Secretary be there, or whoever tomorrow will find out.
Deeply obliged, sir.
Lordship, humble request for item 36. We are yet to file a counter affidavit. If Lordship could kindly fix the matter after 3 weeks.
36.
Yes, Lordship.
You have informed the other side.
Yes, Lordship.
Yangarvati? Any central government council? It is in the hearing list, so whether Mr. Yangarvati is available. You have informed?
Yes, Lordship.
You have already informed?
Yes, Lordship.
Okay, Mr.
Pangum Debrekhemat.
Learned Counsel for the
Respondent number 1.
respondent number 1.
Yes, Lordship.
This is RFA. Why RFA you need to file affidavit?
Actually, Lordship, we are supposed to file a counter affidavit, but then we couldn't.
This is not writ petition that you go on filing affidavit. It is a first appeal. Yes, madam.
Your Lordship, I am appearing on behalf of my senior, Mr. Yamagata.
Okay, Miss
Asikiri.
So-and-so learned counsel for the appellant is present. Mr. So-and-so learned counsel appearing for the respondent number 1 has sought listing of the case after 3 weeks. Full stop. In order to file pleadings. The prayer made on behalf of the respondent number 1 is allowed, list the case after 3 weeks. In first appeal, we don't need pleadings. We go by the records unless some new things come. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention 30 and 31. Your Lordship, actually, I want to take up this one because it's 2016 matter. This was taken up by our Lordship, Devashish, Your Lordship. However, on the request of the petitioner, the case was released. So I intended to take up this matter. However, due to some medical emergencies, I have to rush to Dimapur. So if this matter can come up on Thursday, if this
Thursday will be difficult now.
then Friday, Your Lordship.
Maybe no Friday.
Then
Some other day, madam.
Thursday at 2, no.
Then you get it immediately after vacation, then 7th. 7th of.
No problem.
Okay, Mr.
For the petitioner, Lordship.
Yes, what is the matter about otherwise?
Your Lordship, it is relating to custodial debt, Your Lordship. Your Lordship, previously you said this honorable court has taken up. I mean, like if I refresh, you might remember. It's a custodial debt. The petition has come before this
Did I
court.
take up earlier?
Yes, Your Lordship, and because of that postmortem report, like it was not legible, so we were directed to bring the
Okay.
original records. So they came that the petitioner was tortured. Due to the torture, he died in the custody. But our contention is that no torture has been made it out. And
Yes, Mr. So-and-so land council for a petitioner is present at the request of Mr. Some amicus is also there.
and my case is actually this matter actually it was partnered and it was taken up, but on the last moment the counsel of the petitioner say that he need to take some
Okay.
instruction.
The request of Ms. Levika, Land State Council, who has cited medical emergency, the case stands adjourned to 7th of October 2025.
Much obliged.
Much obliged.
Item? Below. Item 27. Oh, that one. Yes, instruction regarding appellate authority. Okay, we'll come at 2. Yes, madam. Instruction.
Lordship, first appellate is under the School Education Department, is Principal Director.
Principal Director.
Principal Director. And thereafter, second appeal, it goes to the State Information Commission, it goes like that.
Principal Director.
Principal Director,
Are you sure?
Lordship.
Yes, anything to say? By the state?
Lordship, in the read petition, I have instructions to appear for some of the respondents' minutes. So
You are for private respondents?
Yes, madam.
Yes, what do you say about the state? Because this is against the state. This IA. That is disclosure of information, which the applicants are stating that they are personal information by nature.
Has to be protected.
Say regularization, their educational mark sheet. Yes, disclosure of qualification, I have seen. Disclosure of academic qualification. If it is required in a larger cause,
Yes.
Exactly.
then it can be disclosed. But at the same time, marks. Yes, he is BA, okay, BA honors, BSc honors, MA. These are, if required for greater public interest,
Yes.
yes. But so far marks is concerned, that is something like invasion into privacy. And page 41 said that you give all this. That these are matters which is subject to appeal. We are not observing anything. But this is a matter, normally, if these things come, a notice should be given to the employee because they are already employees
Of course, Lordship.
of the department.
Since 1997.
So if it is the
2007.
employer-employee relationship
Yes.
governs that they should not disclose just the mark sheet and all. But if it is required for greater public interest, different thing, but at least they should be put to notice. It appears they were not put to notice as required under section 11. So we are not into, because there is an appellate authority, we are not going into this, but this is an offshoot of the litigation.
Yes.
But in this, how can we do it?
Just.
And this is an IA which is unrelated to.
Yes, just one small
Because
submission, Lordship.
the subject matter of the writ petition, somebody else, X, Y, and Z, has made an application under RTI. Right? This is an interlocutor application in the writ petition.
Yes, arising out of the main writ petition.
But I don't think there is anything connecting.
Yes.
Because I don't find, because you are agitating your interest as seniority.
Yeah, exactly.
Right.
Exactly that.
In the writ petition.
Yes.
How this is connected? Because we cannot just for the asking, we cannot exercise our judicial power of judicial review. It has to be in an application. It has to be connected. This I should arise out of a cause of action. We don't find.
Just a small submission.
Individual writ petition? Yes.
Just Lordship. Just my humble submission to my Lordship judicious mind. I filed this IA because 6 at my paragraph 6.
Madam, what I suggest, please, you convert it to a file writ petition. I'll give you liberty in the morning itself. I'll
Yes.
pass in. individual order will dispose of this. Not in
Cause
this IA, because otherwise this is not connected. It is completely a separate cause of action.
separate. Just my,
I'll give you the liberty not to disclose till the
Lordship.
filing of the appeal.
lordship.
I'm not here to
Lordship.
advise you, but
I give it
yes,
to my lordship.
that part, that notice was not given to you prior to the direction for disclosure.
Exactly.
We'll observe, then we'll give you the liberty to file the first appeal before the first appellate authority.
That
And
will be
till
the-
that time, this information is not to be disclosed, subject to what the appellate authority decides in the interim or final.
I leave it to my lordships. I leave it to my lordships wisdom.
With liberty to file individual writ petition.
Yes, just that the why I
You
watched
wait
this.
till 10:30 tomorrow. No discussion further. I have understood your case. We'll go by the Right to Information Act and the provisions of it, not connecting this.
Yeah, yes, it's separate.
So we'll close this with
Lordship,
the liberty to file individual writ petition.
lordship.
Heard Ms. J. Jimomi, learned counsel for the applicants, that's writ petitioners. Mr. Imti Ingcham, learned additional advocate general. Additional advocate general for the state of Nagaland. Also heard Ms. learned counsel for.
Lordship, there are quite a few of them, so I've written it in a piece of paper.
Opposite party does respondent number so and so. First of the instant interlocutory application is preferred by the applicants who are the writ petitioners in the accompanying writ petition, WBC number so and so, raising an issue in connection with an application preferred under the Right to Information Act by one. Who is that man?
His name is Holodawomi.
Where is that? The spelling?
I give my lordship the second page.
So and so. Who is not a party in the accompanying writ petition?
Yes, the lordship.
Full stop. In the above view of the matter, comma, the instant interlocutory application is found to be found to have arisen out of an issue which is not connected to the writ petition. Therefore, the instant interlocutory application is closed, granting liberty to the applicant. Sorry.
The petitioners.
The instant interlocutory application is found to have preferred in respect of a cause of action, which is not directly connected with the accompanying writ petition. Therefore, the instant interlocutory application stands closed. Full stop. Granting liberty to the applicants to prefer appropriate remedy.
Lordship.
Before this appropriate remedy. Full stop. Close. Make a mention 10:30.
Lordship.
Lordship, in the writ petition, if I may be allowed some time to file my power as well, my.
What has
speed
happened?
ability
Oh, some who made some submissions regarding
Deletion of name.
deletion of name.
Petitioner, yes.
So have you filed any application?
Lordship, you have not filed, we'll be filing today.
But the process is that you have to take NOC from Madam
Yes.
to file an application,
Yes.
right?
Yes.
Otherwise, preferring an application seeking deletion of name without the consent of the learned counsel for the petitioner is an issue of propriety.
Exactly.
We have come hard in the principal bench.
Yes, Lordship.
So Madam will give definitely NOC, but the procedure has to be followed.
Lordship.
Okay. Mr. Heard, Ms. J. Jimomi, learned counsel for the petitioner. Mr. Imti Imsong, learned additional advocate general, Nagaland for the state respondents. And Ms. Lucino, learned counsel for the respondent number so and so. Full stop. Also heard Mr. Fosego Forte, learned counsel. Mr. Fosego Forte. Mr. Forte, learned counsel, has submitted that he has instruction to appear on behalf of few of the petitioners herein, who has expressed desire to exempt, who has expressed desire to seek deletion of their names from the area of parties in the petition. Also, Mr. Vote has submitted that the appropriate pleadings will be filed following due procedure. Okay, first stop. We'll do that. Yes, what?
Maybe allow 3 weeks time to file my power as well as my.
Okay, and Mr. Imsong, same. Okay, Mr. Imsong, learned additional advocate general Nagaland has prayed for and is granted 3 weeks time to obtain the necessary instructions and to file counter affidavit on behalf of the state respondents. Post up. Ms. Lucino, learned counsel, appearing for, has submitted that she would file power on behalf of the respondent number so and so shortly, and has also paid for 3 weeks time to file a counter affidavit on behalf of the state respondents. The prayers made by Mr. Imsong and Ms. Lucino are allowed. Full stop. Okay. List the case after 3 weeks. You in the meantime file seeking deletion after following.
We will. Lordship, just my lordship, page 19, that a judicial declaration as a court officer, whether my lord can whether my lord can quote this this one, my own declaration.
Which one? Page 19.
Yes, 19 of
Where? The IA.
Yeah. Because it's creating lots of confusion and problem and even threatening the petitioners that also has arisen.
19.
Yes, page 19, a judicial declaration.
This will not.
Yes, that is just my humble prayer, Lord.
Relation to action of any
But,
case is limited to. Oh, no, this. That you file a separate IA. As the main prayer in this interlocutory application is a cause of action which is not directly connected to the accompanying writ petition. Ms. Zimobil and counsel for the applicants, the petitioners has sought withdrawal of the application, with liberty to seek appropriate remedies for different causes of action. I keep it open for you.
Highly obliged.
We are concentrating only on RTA issue. First,
I'll be in the main writ petition.
that will be in the main writ petition. You seek whatever.
Lordship. Highly obliged.